second part of the presentation is in respect to transmission. Now we are more concerned with the share transmission. Now we are more particularly concerned in the context of nomination of shares. Few years earlier there was no provision for nomination in case of shares. There is a provision for nomination in a cooperative housing society under Banking Regulation Act, under Insurance Act, but there was no provision for nomination in respect of shares. But once the depository system was brought in, dematerialized shares were brought in, thereafter the concept of nomination was also brought in, and section 109A under the Companies Act 1956, this new provision was added a few years back, whereby a provision for nomination has been given. And this is a very important provision. You need to really understand that every holder of shares, in substance it is that the holder of shares or debentures can nominate person to be the nominee. Now there is a major difference between a nomination made in respect of shares or debentures and a nomination under the Insurance Act or Banking Act or Housing Cooperative Societies Act. Now until last year, really not much attention was paid to 109A. Last year a case came up before the Bombay High Court where Justice Roshan Dalvi went into the depth of this particular section and came up with a judgment which has actually unsettled, so to say, the settled law in respect of nominee. Generally it is understood very clearly that nominee is a person who is in the position of a trustee holding the property for the rightful claimants or rightful legal heirs till it is passed on to them. So when LIC pays a claim, it pays a claim to the nominee, then who is actually entitled, how much, who is entitled has to claim and get from nominee, or nominee has to ensure that the money go to the respective persons who are entitled. Suppose there is a will, as per the will A, B, C, D or X, Y, Z are entitled in particular shares. Then it is the job of the nominee that he just holds the property in trust. Same is the case in case of bank accounts. Banks are concerned with the nominee, and nominee is holding till the rightful claimants prove their claim and he has to hand over the property. But not so in the case of Companies Act, and that is what Justice Roshan Dalvi said. And what is the reason for that? Here if you read the last line, the company shall vest in the event of his death. Now, the words which here are again highlighted, the government shall vest in the event of the death of all joint holders. Now, here in the subsection 3, which is the one because of which the real problems have been created, the nominee shall, on the death of the shareholder or holder of debenture of the company, become entitled to all the rights in the shares or debenture of the company in relation to such shares, to the exclusion of all other persons, unless the nomination is varied or cancelled in the prescribed manner. So all the rights are vested, entitled to all the rights to the exclusion of all other persons. So here, Bombay High Court has held that the nominee is the owner for all practical purposes and he can deal in the manner he or she deems fit. And if the other person is claiming that I am the legal heir, go to the court, fight it out, do. But so far as this particular provision is concerned, he is not merely a trustee as held in other cases. Here he can dispose of the shares. He can transfer to himself, to anybody in his family. No issues. Court will not interfere. At least that is what the Bombay High Court has interpreted it. And of course, the interpretation is best based on provision here because shall vest of the rights. In the prescribed, once the prescription, nomination in the prescribed manner is there, then all the rights shall vest. And that is the thing. vesting of all the rights, that has created a real issue. When the shares are in a physical form, or even today still small quantity in case of listed companies and in case of unlisted and private companies, they remain in physical form, then each company you have to give a nomination. So your nomination is only in respect of those shares of that company. But with the depository, one nomination to one depository and your entire wealth relating to all the shares and debentures in various companies get covered.
The will doesn't come into the picture. I mean,
Will have its own, so you have to enforce later. But so far as the company is concerned, you cannot get a stay.
I'm talking about a demat account.
Yeah.
So all the shares in
Straight
demat
away.
will go straight away.
Straight away.
But then there will be only one nominated.
Exactly.
Is there a provision for making more than one nominee? In that? You can't.
Nominee can only be one.
Yeah.
And all the joint holders have to put their name. Now this particular matter, of course, yet to be tested by the Supreme Court. That is one, and secondly, it is Bombay High Court. So enforceability is restricted to Maharashtra, and there are still several issues about that which are not very clear. And efforts are on that government amends this provision, because this particular Companies Act in any case is under change, and the new bill is pending before Parliament. So but this provision should be in line with the banking and insurance provision, so that the nominee remains a mere trustee without becoming the ostensible owner of the property, where he can even sell off. So this judgment went further, that the intent of the provision and the way provision has really been drafted and now interpreted has created our intention. Nominee, the very term nominee and the way it has been over the years under the Insurance Act as well as under the Banking Act is that vis-a-vis the institution, the finance, whether the bank or the financial insurance company, their obligation is over, so that they don't have to entertain claims. And the nominee holds interest, and then whoever is claiming, he can claim against the nominee, but not against the company or against the bank or insurance company. And same was the intention here also, that company should not get entangled with several claimants, let there be a nominee. But while drafting, these words have come in, all the rights shall vest, and these words to the exclusion of all other persons. That has created the problem. Once that is removed, then things can change. But at the moment, there is this little confusion, and it will take some time before it is cleared as such. Executor